SJC-11752, Sarah S. Kim v. Appellate Division of the District Court, Northern District, and others.
Good afternoon, Ms. Kim. Just give us one moment, and you should approach the microphone so you're all set to go. And you may proceed. You've got 10 minutes.
Thank you, Your Honor. I'm tremendously grateful to Your Honors for giving me this opportunity to argue, the basic issue of lack of standing and jurisdiction. And certainly, the way how I research it, tremendously is that, certainly the Rule 12H3 or, the Rule 60B4 certainly originated, from federal rules that is absolutely a party, parties' right to notice and then, to bring that issue of lack of subject matter jurisdiction is absolutely unwaivable. And then our Rule 12H3, the rule, that dictates that issue, certainly the federal rule always says that lack of jurisdiction, that issue can be brought anytime at any proceedings. And then our rule says that that issue can be brought until final judgment after the appeals. And then after I check thoroughly the federal rules is that, for example, Justice Ginsburg, opinion that named Rugus AG versus Marathon Oil Company, and then certainly that court specifically, that dictates or rules that issue of lack of jurisdiction can be brought even at the highest level. So certainly, that SJC of our state court at the highest level, but certainly, in order to have that, the important, the issue of justiciability, by the court, that according to, that Article 3 and then the Constitution, that the court's power really has to be determined based on, the underlying facts, and then especially in this case, that applicability of underlying statute, whether, that could be adjudicated by the court. And in my case, that appeal from single justice to, the full court, it was not brought directly from the initial statutory action, and that the stage was that somehow passed, and then by facing emergency situation, then after that the district court, that somehow misunderstood the whole thing, and then not exercising, the power to determine the superior ownership of property as dictated by this court that, entitled Bank of America versus Rosa. At that time, it was very, very fundamental to litigants that I thought that district court would deal with even eviction action more carefully by as analyzing and by finding out that seriously based on the evidence, but certainly in my case it was not done.
Now you brought this under Chapter 211, Section 3,
yes,
which
Your Honor.
Usually we would hear only when it's extraordinary, as opposed to allowing you to go to the appeals court to bring it. What's extraordinary about your matter that we should decide it and not have it be decided by the appeals court?
It had gone to appeals court, but certainly, as I wrote in my, the memorandum of law, which I plan to, present to a trial court, that since the case was predicated on the statutory, the statutes, that certainly, that showing or that asserting or barring that. They were filing, the action against me to foreclose based on the existing statutes. And then for that reason, I really emphasize in my, the writing that the trial court judges absolutely took that, fraudulent averment as a fact or facts. So then never and ever the chance, that the chance was given to even explain that, that there is no statutory injury whatsoever. And then for that reason, certainly at that time, knowing that, the somewhat, the issue of lack of, the jurisdiction, especially under the relevant statute, that, and then also that the attorneys, they somehow, they sent me a letter that if you pay somewhat $5,000, that is the whole attorney's fees, then they would drop the suit. So then certainly knowing that there was, I didn't cause any financial injury to the trustees, so I didn't, somehow at that time, so I didn't appear. And then all of a sudden, they changed their mind, and then all of a sudden sent me, a notice for sale. Absolutely then, at the same time, without having any the statutory, the order, the authorizing them, to do foreclose my unit. So then, certainly, I prepare even 5 motions, including, the motion to disqualify, not to mention that, lack of jurisdiction. And at the same time, but it was only I think they noticed by the appeals court that I was saying that since the property in issue is registered land, that, I was emphasizing that the case should be, that decided in land court, not the superior court or district court. So then it was narrowly either construed or absolutely in a word, without, how that is exaggerating at all, that simply because of the nature of a complaint, as I said, in order to foreclose my unit for the wrongfully alleged, all those financial, delinquency. So for that was the reason that I never was given any opportunity, let alone, allowed to have evidentiary hearing. And then that, a prejudice caused by that absolutely first, that unverified complaint, certainly, that has to be scrutinized. So, and then, as I mentioned, that since my case involves my separate properties, both of them I paid in cash, absolutely. Even I had to write out every single month, of my paying that condominium fee. As your owner, knows very, very well that, even your owners heard the case involving the condominium priority lien case last month. And then that attorneys who absolutely came after me by wrongfully, misusing, the statute, knowing that, absolutely there was no statutory ground, to pursue. But somehow, at certain point, they knew that I was not going to be silent anymore. And then, so then they decided absolutely, in a better, a word, to crush me, because, and then knowing that, as I also wrote in my memo, that in order to, obtain jurisdiction, and then they absolutely that was on the first ground. And then they knew that they could easily deceive, the trial courts, by just, that filing that, falsely alleged, facts. And even, it was so interesting that to have found out that even 1946 U.S. Supreme Court that, written by Justice Black, even there was that, old case that, certainly, that, jurisdiction has to be denied if simply a party filed a complaint, fraudulently, just to obtain jurisdiction, to harm someone, absolutely groundlessly. And then, as I mentioned to you earlier, to your honors, that since, that in my case, after the Rosa, the decision, somehow, since it started in Chelsea District Court with my first, property, that, and then also all those, there is no binding judgment and order whatsoever. And then just everything was overlooked. Even I filed at that time my own answer, but they even filed already that wholly, they're drafted the so-called judgment and order, saying that the first phrase was that I was I defaulted, and then but the judge simply, without giving any chance even to they review, what the facts were, and then not to mention that, not knowing or, the not giving themselves any time, to look at, statute which was alleged. So then it's just simply, they endorse their, that, or, that in its entirety that the council drafted like a completely wrong judgment order. And then even after that, even the clerk there, they never made an entry of the final judgment order. And then my counterclaim was even never reviewed. And then that was a long time ago that, that when the, certainly any person who lost or who to lose in district court level, then, there's a trial de novo.
All right.
Anyone
I think the red light means that I'm afraid your time is up. So thank you, and we'll take the matter under advisement.
And then one last, the question then, Your Honor, if Your Honor would, order me, then I can file, regarding that this jurisdiction issue, separately, if you give me just a few days,
All right, I think we will consider the motion to stay as part of our overall decision.
Okay.
Thank you.
Thank you.